Resuming debate. Reprise du débat. The honourable member for North Island, Powell River.
Thank you, Mr. Speaker. Imagine waking up one morning in beautiful British Columbia. The sun is out, the birds are chirping, and you can see the mountains, the forest, and if you're lucky, maybe even the ocean from your home. Life on the surface is actually pretty good, but that scenic reality masks a much deeper and much darker anxiety. The title to that home, that deed that you signed however long ago, may no longer mean what you thought that it meant. The financial investment that you built your entire life around, your home that you spent your entire life saving up towards, may no longer belong to you, at least not in the same way that you thought that it did. I wish I could say this was just some sort of reoccurring bad dream for many BC homeowners. The truth is, however, is that this uncertainty is already their reality today. This past August, the BC Supreme Court issued a landmark ruling that has since reverberated across the province and in time will undoubtedly reverberate across the entire country, recognizing Aboriginal title over 800 acres of riverfront property in Richmond, BC, including over the personal homes of individual citizens, declaring fee simple title invalid and ruling Aboriginal title a, quote, prior and senior title to the land. What this all means, well, no one really knows, which is a big part of the problem. But the ruling, which is now known as the Cowichan decision, has shaken BC politics to its core. And because around 95% of BC was settled without formal treaties, the consequences of this decision are not limited to 800 acres in Richmond, but potentially nearly the entire province itself. And while the decision is, of course, being appealed, and while the result of that appeal remains unclear, the consequences of the ruling are already being felt today. Homeowners are now being taxed on property that legal status is uncertain. Some are having difficulty selling their home, while businesses and industry groups have pulled billions of dollars in investment out of British Columbia as one of the key guardrails of the rule of law begins to break down. When a citizen pays their taxes, follows the law, maintains their property, and still cannot be certain that they own their own home, something has gone profoundly wrong. Private property rights are not a luxury, not an appendage to our system of government, not some kind of optional add-on to our society, to our democracy. They are quite literally the foundation on which Western civilization, capitalism, and our economy are built on. They form the basis for your savings, for your security, for your independence, for your autonomy as a human being. Without them, you own nothing. You are a slave to your government or whatever other powers there may be. And to have them infringed so suddenly, so brazenly, so harshly, without compensation, flies in the face of everything that it means to be Canadian. But it also wakes up a very important fact, that Canada is one of the few democracies in the world today without property rights enshrined in our Constitution. Left out of the Charter of Rights and Freedoms in 1982 by our old Prime Minister, Pierre Elliott Trudeau. And decades later, we are now living with the consequences. As a member of Parliament for a riding in British Columbia that itself is comprised of entire communities and homeowners facing similar legal uncertainty, it is my duty to speak out for my constituents and articulate my position and my views on this issue. For me, the defense of private property is and always will be a red line. It is not and should never be up for negotiation. It is in every way a fundamental human right, and we must never submit to trade it away simply to appease or placate the latest ideological fad or in the name of political convenience. Every citizen must know that their government will do whatever it takes to ensure that Canadians can trust that what they own is truly theirs without exception. Unfortunately, that is the exact opposite of what the Liberal government in Ottawa and the NDP government in BC has actually done. First, in 2018, the Liberal government instructed its lawyers, the Crown Counsel, to abandon their own citizens, ordering them to discard the long-held legal argument that the granting of fee simple private property took precedence over or extinguished any Aboriginal title claim. That directive remains Liberal Party policy to this day. Second, after the bombshell Cowichan ruling, the Liberals should have immediately halted any further agreements or treaty negotiations with First Nations unless explicit protections for private property were included. Instead, again, they did the exact opposite, pushing ahead with the controversial Musqueam Agreement that essentially recognized Aboriginal title over much of Metro Vancouver and nearly 1 million Canadian homes, with zero explicit protections for private property. And a member of Parliament, that should be noted, within their caucus, who has called for, in his words, the return of unceded land. Then they went ahead and negotiated 3 new, unprecedented sort of quasi-treaties, otherwise referred to as living agreements, all of which involved huge transfers of land and money and resources to individual First Nations, again, with no explicit protections for private property included. And when the Liberals and NDP are pressed on these contradictions, on their claims that they too support the private property rights of Canadians and will defend them at all costs, what is their rhetorical defense? They claim that they are appealing the Cowichan decision and hope that they will win. Well, Mr. Speaker, hope is not a strategy and prayers are not a plan. And the uncertainty created by their actions are already having real-world effects today. This Liberal government must act to restore certainty to homeowners now. They must act to restore confidence to businesses and industry and reverse the billions of dollars in investment that is fleeing British Columbia. And just as importantly, they must act to prevent the further fraying of the social fabric between Indigenous and non-Indigenous Canadians that their policies have caused. You know, before writing the speech, I actually looked up the dictionary definition of reconciliation. And you know what it is, Mr. Speaker? It's the act of causing two people or two groups of people to become friendly again after a falling out, an argument, or a disagreement. In other words, bridging divides and moving forward together. Well, this is precisely the opposite of what the Liberal and NDP have managed to accomplish over the last 10 years. Exactly the opposite. Driving a wedge between Indigenous and non-Indigenous Canadians, playing identity politics and prioritizing virtue signaling and rhetoric over tangible, real-world results. Instead of creating a framework that brought Canadians together as one, I see an agenda that has driven them further apart. Breeding resentment and frustration between communities instead of bridging divides and moving together as one country, as Canada. The vision behind our nation from the very beginning has always been one of working together toward a common goal, of achieving together what we could not accomplish on our own. We need to once again harness that vision, to bring back and realize that mythology of Canada that includes as an essential component the mutually beneficial partnership between Indigenous and non-Indigenous Canadians from the fur trade to the War of 1812. But for that partnership to truly flourish, private property rights must remain sacrosanct. There must be no equivocation on the part of the government. They must never allow fee simple title and the rights of private property owners to be abridged or to be up for debate. In each new agreement with First Nations, these rights must be enshrined. In each and every court defense, the case to defend these rights must be made, and if absolutely necessary, if the courts continue to interpret legislation or the Constitution in ways that undermine Canada's sovereignty, our economic viability, or the rights of individual citizens, then whatever changes to that legislation or even the Constitution, however difficult, must be done. Thank you.
Hear, hear. Hear, hear. Questions and comments. Kisiani commentator, the Honourable Minister for Crown Indigenous Relations.
Thank you, Mr. Speaker. Many concerns about that statement, but wondering if the member opposite has read the Musqueam Agreement. The Musqueam Agreement doesn't reference private property, because it doesn't deal with private property. Agreements don't reference everything it doesn't deal with. We only talk about things that the agreement is about. So just wondering if the member opposite has read the Musqueam Agreement. Thank you, Mr. Speaker.
A member for North Island, Powell River. Motion.
Thank you, Mr. Speaker. You know, I agree with the member across the way. It doesn't mention private property, and that is the problem, is there are no explicit protections for private property in the agreement, and we're currently in a legal scenario. We're in legal limbo as we await the appeal process of the Cowichan decision. As we have said as the Conservative Party, as we have demanded, every new agreement, every new treaty with First Nations must have explicit protections for private property. It is a fundamental human right, and that is what we are going to continue to push for on this side of the aisle.
Questions et commentaires.
Questions and comments. The Honourable Member for Gaspé-Les-Îles. Thank you very much, Mr. Speaker. I'd like to thank my colleague, who I appreciate greatly, for his speech. And when I listened to him, I was wondering what is he really proposing? What we see in this process is that the Conservative Party is attacking the guideline number 14, saying that we didn't provide a description. And when you read this guideline, it's possible for the Attorney General to plead for explicit title claims. But now they're talking about stronger property protection. I just want to be sure, are they asking us to reopen the Constitution and to write property rights into the Constitution?
Member for North Island, Powell River.
Thank you, Speaker, and I thank my honourable colleague for the question. The first thing to do is to remove these guidelines that have legal guidelines that have restricted our Crown Councils from defending private property rights with all of the tools in their toolkit. Number two, there should be no further agreements or treaties made with First Nations without explicit protections for private property embedded within. And then as far as what comes beyond that, what has been my position, as I believe is also the position of my colleagues, is when it comes to defending private property, whatever it takes. Obviously, we are going to support the appeal of the Cowichan decision through the courts, but there is no step along this way, along this path, where we are going to allow the private property rights, the fundamental human rights of our fellow Canadians to be abridged and to be up for debate.
Hear, hear. Questions, comments. No member for Okanagan, Lake West, South Kelowna.
Thank you, Mr. Speaker, and I'd like to thank the member for North Island Powell River for his intervention today. And all throughout today's debate, Liberals continue to say that it's Conservatives that are being divisive, that are creating misinformation, among even worse items. Now, the mayor of Richmond, Mr. Brody, Malcolm Brody, wrote in a letter from the city to all the landowners that were affected. The city of Richmond was the only party at trial arguing that the Crown grants of fee simple necessarily extinguish Aboriginal title. The federal and provincial crowns were each laboring under litigation directives that constrain their ability to argue extinguishment. So, Mr. Speaker, my question to the member is this. Does the member believe that the mayor of Richmond, Malcolm Brody, is offering misinformation and being divisive, or is he simply calling out both the federal and provincial governments for their failures to make arguments to protect BC's private property owners' rights?
Honourable member for North Island, Powell River.
Thank you, Mr. Speaker. I thank my honourable colleague for the question. What the mayor of Richmond is doing is he's simply stating the facts as they are. This federal government and the provincial government in BC failed to make legal arguments to defend private property. That is a fact. But what is maybe even more inexcusable is after that court decision was made, they continued to go out and sign agreements, whether it's treaties in British Columbia or the Musqueam Agreement, that did not explicitly protect private property in this new era of legal uncertainty that we now find ourselves in. That is not fair to homeowners in BC. That is not fair to private businesses. And we need to get a government that is actually putting the private property rights of Canadians first. Hear, hear.